My name is Leanne Chin. I work for Advocare and I'll be facilitating the webinar today. This is webinar 3 of our 4 webinar series. And welcome to those of you who are joining us in person and online via our YouTube channel. Our first 2 webinars covered the foundations of recognising, responding and preventing elder abuse. And we have also taken a more in-depth look at case examples from vulnerable groups and communities. Now, back in October, when we asked over 70 financial counsellors what they wanted to see covered in this training, most said that you wanted to know more about enduring powers of guardianship and attorney. And recognising that this is an area that requires expert input, I am delighted to be joined by our expert panellists today. And before we go any further, here in Perth, I would like to acknowledge the Whadjuk people of the Noongar Nation and pay my respects to their elders past, present and emerging, and to community members here today. And I acknowledge that the lands we meet on today across Western Australia always have been, are now and always will be Aboriginal land. I would also like to reiterate my thanks to the Department of Communities who have funded this series of webinars, which have allowed us to bring this expert panel here today. And so I'm going to invite each panellist to introduce themselves with their role and a brief summary of their background relevant to financial elder abuse. So it gives me, it's my pleasure to introduce Etta Palumbo.
Hello, I'm Etta Palumbo and the new CEO of Advocare. My background for the past decade or so has been working at the Public Trustee, which is fully across guardianship and administration. So I'm delighted to be here to be able to share some of that expertise with you.
Excellent. And Vani Poynen.
Hi, I'm Vani Poynen and I'm a solicitor at the Seniors Rights and Advocacy Service at Legal Aid, which is a small team within the Civil Law Division. I've only been doing this role since July of 2020, so I'm not sure if I'm an expert, but I'll do my best to contribute today.
I'm sure you are. And Justine Mata.
Thanks, Leanne. My name is Justine Mata. I've worked at Advocare since 2018. Currently, I'm the Program Manager. I have worked in the aged care sector since 2008 and have a lot of experience working and assisting people who are setting up enduring powers of attorney and guardianship. So hopefully I'll be able to make a useful contribution.
I'm certain you will be. And last but certainly not least, Leanne Berard.
Thank you. I'm Leanne Berard and I'm the Sector Quality and Development Manager of the Financial Counsellors Association of WA. And by working closely with financial counsellors, especially in the areas of financial abuse, we have a focus group that looks particularly at elder abuse. So we'd like to talk about those issues and trends that are happening today.
Excellent. So we have a series of common questions to ask our panel, and following this there will be the opportunity to answer some of the questions that you've submitted to the panel through the chat. So we're going to begin by asking Leanne to set the scene for us. So Leanne, can you just give us an overview of the types of scenarios relating to enduring powers of attorney and guardianship that financial counsellors typically see?
So with the financial counsellors, they may have a client that comes in and presents maybe with their guardian or EPA or maybe without, and they're quite alarmed sometimes to see the situation that the client may be in, or ask how could this actually happen. Sometimes they're not able to have that time by themselves with the client, and that other person might be present. So in these situations, they'd really like to know what they can do.
Excellent. So what we're going to do now is delve into some more detail regarding the enduring powers of attorney and guardianship, and again, those case studies and specific questions at the end. So, Justine, can you explain if the laws relating to enduring powers of attorney and guardianship are the same across Australia?
No, they're not. They're not the same. Enduring power of attorney and guardianship are state laws. So each state across Australia has different laws governing how the enduring power of attorney and guardianships work, and also limiting some of their authority. So it's really important that people are aware that if they have set up an enduring power of attorney or guardian in another state, when they come to Western Australia, they need to review that and be aware of what the law allows in this state.
Excellent. My next question is for Vani, and that is, can you explain the difference between an enduring power of attorney, an enduring power of guardian, a legally appointed administrator, and a publicly appointed guardian?
Sure. Okay. Firstly, in relation to the difference between an enduring power of attorney and enduring power of guardianship, so the roles are pretty mutually exclusive. So if you're an enduring power of attorney, you can only do duties in relation to the finances of the represented person, the donor. And if you're a guardian, you make lifestyle decisions, medical decisions, and personal decisions. So a guardian will make, someone who's been appointed as an enduring guardian will make decisions when the person has lost capacity or is unable to make reasonable decisions. They can make decisions like where will they live, who will they associate with or meet, or who can come and visit them, what type of medication or treatment they can have, and also whether they can go out. There's a range of things, but they're all personal, lifestyle, and medical usually. So for instance, there was a case, for instance, to elaborate on a power of guardian and the type of things they do. There was a client who was in an aged care facility, and his wife was unofficially his guardian, and she would not allow the aged care facility to use what she called a chemical restraint, and so he could not, take the particular medication, and it was very difficult for the aged care staff to actually deal with him. And so the aged care facility actually had to make an application at the State Administrative Tribunal to have the Office of the Public Advocate appointed as his guardian. So then they could make those decisions for that person. Now, in terms of the enduring power of attorney, so this is something that financial counselors would usually come across, and that's you allowing someone else to take control over your finances and deal with anything that you can deal with. So like opening bank accounts, closing accounts, changing banks, buying property if relevant, and things like that. So it's completely different. And you can't do things that a guardian can do if you've got an enduring power of attorney, and vice versa. And in terms of the legally appointed administrator, so if someone has lost capacity and a family member realizes they can't deal with things, or they're not taking appropriate decisions, you can actually make an application to the State Administrative Tribunal. It does not have to be a family member. It can be anyone in the community, such as a financial counselor, who makes an application to have an administrator appointed. So that can be a private person, like a family member or a friend, or it can be the public trustee. And then they will execute those duties pursuant to the orders made by the State Administrative Tribunal. So in order to make that application, you would need a medical capacity report, which has been signed off by a doctor to say that the person has lost capacity. That's the one important factor. And likewise with the publicly appointed guardian, if the person hasn't appointed someone while they had capacity to make the decision, so if they haven't said that their husband or their child could make those decisions, then the State Administrative Tribunal an application can be made for them to appoint a publicly appointed guardian
Very nicely explained. There's a question that's come through which I think we can just put to you now, which relates to our previous question and this one, which is, do you need to have your EPA or EPG living in the same state as you?
You don't really need it, but it would definitely make everyone's life easier if they were to do that, just because it will be very inconvenient for the person to do basic things like banking and stuff.
Excellent.
Yeah.
Thank you for that comprehensive response, Vani. And my next question is for etta. So, what is the difference between an enduring power of attorney and a public trustee appointed to manage someone's finances?
Yeah. So it's a little bit expanding on what Vani said. So with an enduring power of attorney, they're obviously able to be made at a point in time where they are made at a point in time where a person has capacity, but they can be made when you have capacity. You say that they're immediate so that a person can assist you in executing the financial needs that you have. Or you can say that they take effect when you lose capacity. In the event, and the courts actually decide, or the State Administrative Tribunal decides when capacity has been lost. So in the event that an EPA has not been made by the person, then to manage the finances, you really do need to go to the State Administrative Tribunal and get legal authority to do so. So that's when you get an administration order. The administration order then allows you to stand in the shoes and do what it is that needs to be done. The big difference is that with enduring powers of attorney, they're a private arrangement between you and the person that you entrust, and that's a really important word, trust, to manage your finances. No one polices them, so there is potential for them to be misused. So you need to think very carefully about who you're appointing. And if you are appointing them immediately and you find that they're not doing what it is you'd like them to do, then you need to think about whether or not they're the most appropriate person. When it's the person is appointed by the State Administrative Tribunal, they will try and go for the least restrictive option, which is going to be a family member or friend. But if there is no family member or friend willing or capable of doing the job, then it will be, or trusted to do the job, it will be the public trustee. In the instance where a family member or friend is appointed, then there is a requirement that the finances are reviewed each year by the public trustee. So in an administration order, they're certainly looked at in an annual basis to ensure that there's been no misappropriation of funds.
Thank you. And this question is also for you, etta. So can someone appoint a public trustee to be their enduring power of attorney? And if they do, what is the difference from having a family member or friend as their enduring power of attorney?
Yes, okay. So the public trustee is considered the trustee of last resort, and it has a very, very large number of clients that it has no option but to take because they're referred from the State Administrative Tribunal for administration orders. If you come in through the State Administrative Tribunal system, if you haven't got the capacity to pay, then there are mechanisms in place where we have public trustee has a community service obligation, and they will still provide the services on the basis of your capacity to pay. If you appoint the public trustee under an enduring power of attorney, it's a commercial relationship, just like it would be you appointing a lawyer or an accountant or another trustee company, and there are fees associated with that. So it may be that the fees you should shop around for fees and see what the best service available to you, and fees that are appropriate to your circumstances. So I know that the public trustee wants to review each person's EPA, because you need to accept the EPA, and the public trustee will look at whether or not there is a more affordable option given people's circumstances. So it may be that if you're a person who's in an aged care facility and all you get is the pension, it may not be the most cost-effective option. If you are a person who is eligible for centre pay or something along those lines, it may be that it's not the most cost-effective options. So the short answer is yes, you can, but there are certainly fees associated with that, and you make a consumer choice.
Excellent, thank you, Etta. My next question is for Vani. Vani, can you explain any potential risks involved with making an enduring power of attorney?
Yep, sure. So the enduring power of attorney by its very nature is one where you make the appointment when you've got capacity to do so, or legal capacity. That means you understand what you're doing in terms of what you've signed over. And it's enduring because when you lose capacity, the person you've entrusted with that power is going to continue acting, and probably more actively now that you've lost capacity. So the sort of scenarios that we see at Legal Aid when we are approached by either different family members or the person who's made the who's actually signed the enduring power of attorney is when there's been a breach of that trust, and the person who has been appointed, the donee, has basically made off with a sum of money or acted inappropriately in that they've benefited themselves. So that is the potential risk. And because it is not really policed, as explained earlier, it is a very risky document and to be treated very carefully. So there is a huge risk for someone to breach or to manipulate or misuse the enduring power of attorney. And that is why, as Etta explained, you have to be careful who you choose, and you have to trust them to do the right thing. And the person who's been appointed should always act in the best interests of the donor, but that doesn't always happen. So, for instance, even without just being a full enduring power of attorney, a similar situation occurred where someone was made a signatory on a bank account, and this lady went overseas for a year, and she made her granddaughter the signatory on the bank account. When she came back, she had sold a property before she left. She had intentions of coming back and making a more permanent arrangement for herself. When she returned, she found out that $160,000 had been cleaned out by her grandchild. And we made an application to AFCA to see if there was anything the bank could have done differently, but she knew what she was doing. She had just entrusted the wrong person. So, the money is gone.
Could you just elaborate on AFCA?
Okay, sorry, it's the Australian Financial Commission, I think. Complaints Authority.
Excellent.
So they will deal with anything where there's a bank involved. I'm sure the financial counsellors are across what they do. So AFCA basically did an investigation, talked to the person who has made the arrangements, and found out that they knew what they were doing. So there was not a fault of the bank. So our advice to that client in that instance is that she would need to start district court proceedings against the grandchild. Prior to that, we did try to make some arrangements, and the grandchild did agree that she had taken the money unlawfully, but she didn't keep up with the payment arrangements that we set in place. So then now the grandparent is in a situation where they have to start legal proceedings. And oftentimes, the enduring power of attorney is usually a child or a family member, and the elderly person is usually very reluctant to start proceedings against them.
Yeah. I think it comes back to what you were saying about the person that you trust.
Yeah. And I think so there's the situation where it can be risky to make an enduring power of attorney, but there's also risks of not making one. You have the informal arrangements that are in place, which can be even more detrimental to a person, especially if they're older or vulnerable. And then there's the situation that if you wait until you've lost capacity, which forces family members to apply to the state administrative tribunal, you have no control really over who's going to be appointed. So there's a downside to every situation, but at the end of the day, you need to make arrangements for a situation when you lose capacity, and it's up to your individual circumstances to determine what's the best scenario for you.
Excellent. I'm very pleased to see that a question has come through on the chat, which is almost exactly the same as our next question. So the question that's come through on the chat is, in cases of diminished capacity, if there is concern with it that the EPA is not discharging their duties appropriately, what recourse measures are available for concerned families and friends? Or our next question, which I'm going to ask Vani to go first with, is explain what, if anything, can be done legally if an EPA is found to be misusing their authority or not acting in my best interest, and what steps can be taken to recoup or redress the misuse.
Okay, so if I still have capacity and I've appointed someone as an EPA and they've misused it, obviously the first thing I can do is to revoke the enduring power of attorney. And that can be done by writing the word revoked or tearing up the document, and also writing and notifying the attorney that you have now revoked their power and that they have to cease acting on your behalf. And you should also send that to all the financial institutions that you have an account with, and also to Landgate to notify them that you've revoked it. If you've lodged it, there's a fee payable upon revocation. The other thing is, you can also, if you've actually discovered that money has been taken, there are legal remedies. You have a 6-year limitation period whenever, from when the debt is accrued. You can start legal proceedings to get that debt back. It's not really a debt because it's been fraudulently taken, okay, but that is the legal civil way of getting it back. Of course, you can make a police complaint because it can be considered stealing and fraud. I think the police try to get people to deal with it on a civil basis first, and often, again, parents will be very reluctant to start going to the police about their kids. So then in our practice, what we do is we try to contact the person who's done the wrong thing and ask them to return. So do it softly and see if they will return the money to the parent or the person who's made the the donor. And if they refuse, then they have to start legal proceedings. There's no way of actually getting the money back if you've already lost it, except by taking legal proceedings or them returning it to you voluntarily. But of course, to protect yourself in the immediate instance, you need to revoke the enduring power of attorney. So that's the basic outline.
And so I might just add, if the person has lost capacity, there's also avenues that you can take.
Yes, that's right. So if they've lost capacity, then if usually we get siblings calling in when they've discovered that there's other sibling has done the wrong thing, for instance, you can then make an application to the State Administrative Tribunal to firstly you've got to show that there's been an enduring power of attorney, that the person who's made who's the donor has lost capacity, and then the State Administrative Tribunal can then make a different decision. They can order that the EPA should be revoked, and they can also appoint either the public trustee or another family member as the attorney, or administrator.
Yeah, and when the public trustee is appointed, it's usually in really dire circumstances. And there is forensic accountants and teams of lawyers that deal with some of those very complex situations, because you will find that an older person has been left largely destitute, which makes it very difficult for them to access aged care and so forth. So there are great efforts put into trying to recover some of that money, but if it's been spent on gambling problems or lavish lifestyle, that's not always possible.
Okay. And we will be looking at areas where capacity is in question in the next webinar, which will be webinar 4 on April the 14th. So our next question is, again, looking at capacity, and for Vani again, how do you know if someone has capacity and is able to make agreements and sign legal forms?
If you are questioning whether they have capacity, that means you've got reason to suspect that something is going on. So usually the things you can watch out for is a person in a hospital? Why are they there? Has there been some sort of a diagnosis? You can talk to them and you can see if you've got some sort of a, when you're talking to them, you can sort of get a feeling that maybe there's something not right. And you can ask them questions in relation to what they're attempting to do. For example, so for instance, if someone's approaching me about signing an EPA, I would try to explain what it involves to them and then question them to see if they, for instance, know the extent of their assets, what they've got, what they want to do with it. But ultimately, the decision of capacity lies with the doctor. And you can get a medical report. If you are not certain, you should get a medical report to ascertain that, whether there's a problem. This is particularly so if you know that there is a bit of conflict between the family and someone's going to question the validity of it at a later date. So if you are suspecting that something's amiss, it's always good to get a doctor's report to cover yourself. And in order to sign any legal document, you need to have legal capacity. Lawyers are sort of half trained, not fully at all times, but we can kind of ask questions to make up our own minds about whether we think someone's got the capacity to sign a legal document. So for instance, with the EPA, we'll try to figure out whether they know what it entails and what the risks are, etc. And if they are not, then we will definitely make sure that we get a medical certificate. Or medical capacity form from a doctor.
Yes, I do know we have a very expert panel, but none of us are qualified to assess people's decision-making capacity. But Leanne, I know that you have a capacity toolkit.
That's correct. So I'm not sure whether people can see this. In September 2020, our peak body, Financial Counselling Australia, developed a capacity toolkit. So that should be on the National Toolkit for Financial Counsellors to access. And that actually goes into some detail as to the warning signs that financial counsellors should actually look for that could imply that there's that capacity is questionable, and what you can and can't do in your role as a financial counsellor. So after this session, I'll actually distribute that through to all the financial counsellors. But there's some great resources also with the checklist that Advocare have developed in regards to people at risk. So you might want to use this with conjunction with that checklist, and that will give you a really good idea whether, one, they are potentially open and vulnerable, and two, how to ascertain that capacity is an issue.
And also, just to mention, capacity is fluid and it can vary from time to time. And there's different levels of capacity required for different type of legal agreements or documents. So I believe there's a different standard for signing a will as opposed to an enduring power of attorney. And also, I'm quite suspicious of medical capacity reports that have been done in a hospital, because a patient could be drugged up and not really, like they might be on oxygen, drugged up, and they are not in a good state. But when they recover, they may be fully well enough to do that. So just because at one point of time they don't have the capacity does not mean they are permanently affected, and that's something important to keep in mind.
And I might just add that capacity is one issue, but undue influence is another issue, as well as fraudulently. Sometimes there's no understanding whatsoever that a person has signed a document which is an EPA, regardless of the fact that they have capacity.
Justine, would you like to add anything?
Certainly at Advocare and in aged care, the common law understanding is the assumption of capacity. So when somebody contacts Advocare, we always assume capacity when we're discussing issues with them. However, if we are aware that the person doesn't understand what we're saying, and you can check that, by asking somebody to paraphrase what you've just told them, if the capacity is in question, then again, we would look at, other measures trying to establish if somebody does have capacity, and then encourage them to, have a capacity assessment, or for those around them to pursue that, or to make an application to SAT, the State Administrative Tribunal, to try and establish if they do have capacity or not.
Excellent. So our next question is for Etta, and that is, can you tell us what we can do if we want to change an enduring power of attorney or enduring power of guardian?
So if it's your enduring power of attorney or your client's enduring power of attorney and they have capacity, then as Vani mentioned, they go through the measures of revoking a particular enduring power of attorney and executing a new one with perhaps a new donor, a new set of limitations and so forth. If the person does not have capacity, then it needs to be referred to the State Administrative Tribunal. That's pretty much the only way you can do it, and that includes if the person who has been appointed is not able to do the job. So back to the tribunal.
And would you add anything here from a legal point of view, Vani?
Well, even when you go to the State Administrative Tribunal, the tribunal still takes into account the views and the wishes of the person who's affected to the extent that they can verbalize it. They may not always take it, they may not make their decision based on what they've said, but they will definitely take it into account. So I've had a client who was deep in the throes of dementia, but she actually understood, when she was clear, she actually understood what was happening. And she actually managed to, she forgot who I was, for instance, when we turned up at the hearing, but she could verbalize and give the exact same thing, instructions that she was telling me when she was able to. So they will listen to them still.
That's excellent. There's a question coming through, I think, which is relevant to be asked now, which is, how long is the process to get the State Administrative Tribunal to overturn an EPA? It says there.
Okay, so you can, if there's a risk of imminent transaction, like something's going to happen, or they've put the house on the market, or there's something imminently dangerous, or whatever's going to happen that will affect the person's property, you can make an urgent application to the State Administrative Tribunal. And I'm not sure of the exact time frame, but you can get a hearing, quite quickly.
Within 24 hours.
Yep. Okay, yep. So that would be one thing that you can do if there's an urgent need for it, but you need to show them that the element of urgency. If not, usually I think it takes roughly about from the time that the application has been put in, approximately 6 weeks for you to get a hearing date. And getting the application in place itself is quite a time-consuming process. You've got to notify all the people who are interested parties, and you've got to get the medical report, capacity report, so there's steps involved in it. So that process itself can take a bit of time depending on how efficient you are. And then once the application is through, SAT usually takes about 6 weeks to give a hearing date.
Excellent. So 24 hours for urgent and 6 weeks for
Really urgent.
Yeah.
Right. Okay, so my next question is for Justine. So Justine, do enduring power of attorney and enduring power of guardian documents need to be lodged, and is their use monitored or recorded?
And
are they answerable to any public authority?
okay, the short answer is no. Enduring power of attorney and enduring power of guardian documents don't need to be lodged anywhere. So clearly the people making these agreements should keep original copies themselves, because really it's a private agreement between consenting adults. So you should keep copies of the documents. However, if there's going to be property involved, then a copy of the enduring power of attorney should be lodged at Landgate. And there is a cost associated with that. And you can go to the Landgate website and they list the costs. They also provide a checklist, so you can go through the enduring power of attorney document and make sure you've completed it correctly, so that it can be accepted by Landgate. So there's a cost involved. People need to bear that in mind. These documents aren't monitored. So even if you lodge an enduring power of attorney at Landgate, they are not going to monitor it and make sure that the attorney is doing the right thing. That is your role as the donor. While you have capacity, you're meant to still stay involved and in control of your finances. I guess it's important and worthwhile mentioning this now that if you do set up an enduring power of attorney, while you have capacity, the attorney should follow your instructions at all times. So they're there to support you, not to make decisions that are contrary to what you want. So while you have capacity, you are still in charge of your finances, even though you have appointed an enduring power of attorney. Are EPAs and EPGs, so enduring power of attorney, enduring power of guardian, answerable to any public authority? Not really. It's only if there's evidence of misuse and you bring that to the attention of a public authority. Or, for example, if you went to a financial counsellor and you were aware that there was a misuse of EPA, then the financial counsellor would be able to assist you to revoke the EPA. If you contacted Advocare, we would do the same thing. We'd be able to assist you to revoke that EPA. If there was serious misuse, you could take legal action to try and recoup the losses, as we've discussed before. But it's really important that people are aware that these are not monitored. There's not a panel, there's no one checking up. So it's your duty, your responsibility to really be alert and aware of what's going on with your finances and with your guardians. Make sure the people you've appointed as guardian understand your wishes and ideally have it documented somewhere, your life decisions, so that if the time comes for them to make those decisions, they're aware of what you want, they're aware of what your best interests are.
Etta, would you add anything to that?
That's a great summary.
Yeah.
I think just in terms of the number of people that you can appoint, so you can have more than one person,
yes,
which sometimes makes it safer, not always.
Some checks and balances.
So we have a question, and again, I think most of this question that's come through is either being answered in what Justine's just said or should be answered in the next question, which is to Vani, which is, does someone need a lawyer to help them make an enduring power of attorney?
No, you don't need a lawyer. The forms are pretty straightforward. You can use the, there's a good guide to the enduring power of attorney which has been published by the Office of the Public Advocate, and the forms are pretty straightforward, so you can execute them yourself. You would need 2 witnesses to witness the document, and one of them has to be someone who's an authorized witness, and the other one can be a normal person, who's not necessarily authorized to witness documents, as long as they are above the age of 18 and they've got legal capacity to do so. So, but however, my advice is that it is good for people to get some legal advice to know what they're getting into. So, you are aware of the risks involved.
Excellent. And we will be sending out learning support materials at the end of this webinar, and we will include links to those documents. I'm sure financial counsellors are aware of this, but just in case, it's a great resource. Justine, would you add anything to that answer?
The main thing I would add is it's so important that you read the documents completely before you even begin filling them in. And I cannot emphasise that enough. We have had so many cases that people have brought to us related to misuse of enduring power of attorney, where people haven't even retained a copy of the document. And when we ask them about it, they say, we didn't read it, we just signed. And you just can't do that. Being aware now that they are not monitored, no one is checking up on these. These are legal documents where you're giving somebody responsibility for your finances and potentially your life decisions. You really must read and understand those documents. And if you don't understand them, perhaps that's when you should seek alternative arrangements, speak to a lawyer, speak to Advocare, speak to somebody who will explain them so you understand fully what you're about to embark on.
So my next question again is for etta, and that's, can you explain what happens if someone doesn't make an enduring power of attorney? And who will manage the finances if you can't anymore?
I think we touched a little bit on this. So if you haven't made an enduring power of attorney, if you've got capacity, you're obviously responsible for your own finances. If that starts to fall away, then family members obviously start to assist, or friends, or next door neighbours, or complete strangers. At the point at which it becomes evident that a person needs some assistance with their finances, and that would normally happen when they enter a hospital, when they're going into an aged care facility, when the bank becomes a little bit concerned or suspicious. There are points at which the person may be alerted, or people may be alerted to the fact that the person has lost or is losing capacity, family members. At that point, an application needs to be made to the State Administrative Tribunal, and we've talked a little bit about that. In terms of the second part of the question was who will be appointed. Well, it's normally family members or friends, and normally people who are willing, able and trusted to do the job. So that's the best scenario, because those people are doing it in the best interest of the person because they know it, and they're doing it for love. They're not being paid for the exercise. However, there are many people who appoint their accountant or their lawyer or some other professional person to be their enduring power of attorney. And they do that through a commercial arrangement, or they can appoint the public trustee or a trustee company. So there's a commercial arrangement there, and you can certainly appoint that nature of person. With the State Administrative Tribunal, they will make a decision about who is best placed to be the administrator. And that could be any of those people or organisations. And as I've mentioned, if it's going to be the public trustee or another trustee company, then there'll be charges associated with that. So they'll make a decision on what's in the best interest of the client, what the client can afford, and so forth.
And if I can add something, one thing that we all need to be clear as professionals is who is really our client. It should be the elderly person and their interests that we are looking after. So we get calls from concerned, children. They have their best intentions at heart, but they realize their mom or dad is not, with it anymore. And then they say, can I sign a power of attorney? And then you've got to be really clear and say it's not your decision, particularly if you suspect they are going downhill, you need a medical report, it's not your call. And the person who's caring for the elderly relative, usually, like Etta mentioned, has got a bit of an undue influence, and they can pressure their parent into signing things. And that's something we really need to be careful and watch out for, because it might not be in their best interests. It may be, but it may not be. So that's where our warning alarms should go off. Why is this child calling me about their parent signing a power of attorney?
And there's often a lot of family conflict that comes out when it's suddenly discovered that one child has has been appointed as the attorney under an EPA, and the rest of the family just go, well, how did that happen? And have suspicions about that or concerns.
I wonder if I can jump in with a question that touches on what Leanne said at the very beginning here, which is, what tips would you have for financial counsellors to see that client alone? That when a client is accompanied by an EPA who might be exerting undue influence, what strategies can you use to?
Okay. Well, I can start off. So as lawyers, we are told, especially when people are signing documents such as wills, and definitely an EPA is in that sort of category, you have to request that you talk to the person alone. If you feel that they still can have some, like they can still give you instructions, and you have to be pretty brutal and upfront and tell them, I'm sorry, but I have to have this conversation alone. Now, we have got a lot of phone appointments, and sometimes the child is there. And what I would do, like what we are usually advised to do, is by the Law Society and bodies like that, is to ensure you tell them that there's a potential conflict. You have to let them know there's a potential conflict of interest. I can only give you advice. I can give you the other party information. And for us at Legal Aid, we let them know that you are the third party or the concerned other. You're not the affected person. You know, the child's not the affected person. We can only act for the affected person. And so if you want, like, they seem to like merge their interest with their interest of their parent. And it's very hard for them to comprehend that they are not the same person. So that process of doing it, unfortunately, it has to be pretty brutal, because otherwise some people just don't take no for an answer. And you've got to let go of your inhibitions about, oh, what are they going to think about me? We don't care, because we are only here to protect the vulnerable person.
Excellent. So, moving on to the next question for Etta. What are some ways I can make sure, or that someone can make sure, that their enduring power of attorney and guardian will make decisions in my best interest or in their best interest?
Yeah, I always say that it's really important to communicate your wishes and plan well ahead. So we find that people are trying to make important documents like wills and EPAs and EPGs at times of crisis, when it's often too late, or capacity is in question, or there's, you know, people with all sorts of competing interests involved. So it's really important that when you get to a certain age, you know, that's probably 50 or so, that you ensure that people put plans in place. And there are a range of plans, depending whether it's for taking a pathway to an EPA or EPG, or to making a will. So it's really important that you plan for your future care and your future living arrangements and so forth. And you need to think very carefully and have contingency plans in place. So if you're selling a home to build a granny flat in your son's backyard, for example, then you need to know the risks associated with that. So think through what you would like to happen, and then have a little risk management approach to see whether or not, what would happen in the event that failed, that property had to be sold, or that person got divorced or whatever. So that's kind of on the care situation. And that will then give your enduring power of guardianship, the guardian, some really clear understanding of what you want to happen as you age in terms of the guardianship issues. With the financial planning side of things, you need to have an estate plan. You need to be really clear about how you're going to finance your future, what sort of support is going to be put in place, should you need some in-home care or so forth, how you're going to pay for it, what will the government provide for you, what will you have to self-fund, how are you going to do that, what happens with your investments. So really clear plans in place in terms of an estate plan about what you would want to happen, and arm your attorney with that. So if you've got those two plans in place, and there's some really good documents that or organisations that assist to make those, then you're providing your EPA, your attorney or your guardian, with not only the tool, which is the EPA or EPG, but a clear set of instructions about how you want to age and finally demise.
Excellent.
Sorry, Ran. And I think for us as a sector, those preventative information for clients will go a long way, because it's very reactive at the moment, and we're finding that there isn't that forward planning or thinking. And as you said, in crisis mode, it's like, oh, better get this sorted now. So, maybe as a sector, when we're looking at community education, maybe making people aware that there's a lot more to the EPA that probably they're aware of, and the risks associated. And I'll refer back to the great resource that for financial counsellors that could be given to clients, and that's similar like to the Money Smart information. So that's your money, your life, your choice. And I think it goes into things like granny flats and what are the risks associated. So that's a great tool as well.
Yes, we highly commend that resource, which is an Advocare resource. So thank you, Leanne.
No worries.
Etta, I have another question for you, which is, do I have to pay, or should my enduring power of attorney or enduring power of guardian be taking payment when they help me? For example, would they be able to use my money to buy a car if they are driving me to appointments and shopping?
The answer is generally no. The person is doing the role on a voluntary basis, and they are using funds in the best interest of the client and not their own. So appreciating that there's sometimes a lot of effort and energy put into being an EPA or being an attorney or even a guardian, you cannot take payment. And you need to be very careful about how you use funds in terms of gifts and so forth. You can't give gifts or loans and those sorts of things. So you need to be very careful about always using the funds in the best interest of the client, because if you don't, there's sort of the please explain scenario. So in the topic of the car, it would be very unreasonable to purchase a car for such incidental things. So I would say absolutely not. But there are some very limited circumstances, for example, where you might have an older person or a person with disability that has very special needs for a very special type of car that's within reasonable limits in terms of what a prudent person would purchase for it. So there may be these exceptions, but certainly not for that sort of reason.
Leanne, is this something financial counsellors might encounter?
In respect to what?
People taking payment for maybe inappropriate.
I haven't any case studies as such. Like when we meet as a group, a lot of the concern is probably about care packages that leave a person without funds. I haven't heard about spending, but we do hear about people coming in and their personal items going. We do hear about their food being eaten or taken, so they're left without food and having to have emergency relief to cover those. But I'm sure there would be financial counsellors that have come across,
adding the shopping items.
Yes.
Shopping list is a very, very common one.
Yeah.
Also, you can always apply to SAT to give you directions. If you're an enduring power of attorney and you're not sure whether you should do a particular transaction or whatever, you can ask SAT if it's within your authority to do so. They can't they can't make the order for you, but they can tell you whether or not you've got authority to do something. And also, it's important to also remember in the enduring power of attorney document itself, you can write some restrictions for accounts to be provided to your other children, etc. There's limited number of things. You can't make it too restrictive, but there are certain things you can include to prevent, to make them more answerable in a sense. Yeah.
And it's really important that when you do go to get some directions, remembering you're doing things in the best interest of the client. So it may be that the client is wants to do things that are a little bit out of the ordinary, or they're used to doing things. They go on an annual cruise and they'll need someone to go with them. And the payment for that, where does it come from? So it's those sorts of things that could very well be in the best interest of the client, but you need to be very, very careful, and seeking instructions is probably the best way to do it.
Okay, my next question is for Justine, which is, can my enduring power of attorney make decisions about where I live? For example, could they decide it was in my best interest to move into a residential aged care facility?
Again, the short answer for that one is no. So an enduring power of attorney can't make life decisions. So as we've discussed earlier, the enduring power of attorney can assist with finances and property matters. So they don't have the authority to make decisions about where people live. That's a guardian could do that, but that would be if there was evidence of a loss of capacity. So no, an enduring power of attorney cannot decide where someone is going to live. So the example that they've listed is, could the enduring power of attorney decide somebody was going to live in residential care? Sadly, we have a lot of cases that come to Advocare where that is exactly what has happened. Frequently, it's connected with a hospital admission, and the enduring power of attorney makes the decision that the donor, and frequently it's a parent, an older parent, would be best served if they were in residential aged care. And a lot of the time that decision is also influenced by what the people in the hospital are saying, what the doctors and the social workers are recommending. However, if the older person, the donor, has capacity, then their decision is what counts. So they need to decide where they're going to live. So if the older person, the donor of the enduring power of attorney, wants to return home, even if that is contrary to what the doctors and everybody else wants, that's what should happen. The older person should return to their home, hopefully with a lot of support, and hopefully the social workers will respect that decision and back them up with some support. But it's really important that people understand that the enduring power of attorney doesn't have the authority to make life decisions, and if the person has capacity, then their wishes should be followed. There is, and you can see there in the hierarchy of decision making, that is something that applies within the health system. There is actually a hierarchy of decision making. So in an emergency situation, the health sector will actually go through the hierarchy, and at the top of the hierarchy is an advanced health directive. So a correctly completed advanced health directive is at the top, and then there's the wishes of the next of kin, and then I think it's close relatives, etc. And you work your way down the hierarchy, and I think an enduring power of attorney is about number 5. So as you can see, they're not top of the list. So really, an enduring power of attorney should only be making that kind of decision if it's within the hierarchy in an emergency situation. And if the person has capacity, then their wishes should be followed at all times.
And I'll just add, having been in that situation a number of times where a hospital and a team of doctors and a social worker are all saying, no, mum can't go home, she must go into residential care. The pressure sometimes is extraordinary. Yes. So it takes a very strong person, and I think of a very strong person, to be able to push back against that. So it's kind of an easy option, and one that we all need to take responsibility for, to try and help older people to stay out of residential aged care if that's not what they want. Sometimes it is in their best interest and they do want to go down that path.
And that's really an interesting and important point. We actually got current cases of that ilk, but so there is a pressure on hospital staff and social workers to not let people languish in transitional care, for instance. So they think that this person's not going to be able to cope on their own at home. They really think they should go into a permanent aged care. And the problem is, in the Act, it doesn't say that the person must completely lack capacity before SAT can make an order for them to be moved wherever. It just says the person doesn't have the capacity to make reasonable judgments, okay? So this gives too much power, I think. It takes away a lot of power from the person who's affected, because the personality of a person might be very strong and obstinate, and they just simply don't. This particular client of mine, for instance, she says very clearly that she would prefer to die at home, and that's her wish. And actually, unwittingly, hospitals and other professionals can become part of the elder abuse when you put your wishes very strongly against that person's wishes. Even I know it might not be ideal for them, but if that's what they want and they've got reasons for saying it, who are we to push that on them? Okay, so that's a sort of an ethical dilemma for a lot of professionals.
Yes, I know your elder abuse specialist services, seniors rights service, and we too are a rights-based organisation. It's a very important principle.
Yeah. And you need to be really quick to jump on that, because it becomes a spiral that then they're stuck in the situation of having to remain in residential care. So once they find themselves in there, if it's not working for them or not what they want, then people need to assist to exit them and back into the family home. Once the family home gets sold or their rental accommodation is removed from them, it is very, very difficult to then transition back into the community. So, there needs to be very careful consideration given into the implications of making such a rushed decision in crisis.
Yes, and I think that leads on nicely to the next question, Vani. When does the enduring power of attorney come into effect? So when can an enduring power of attorney start acting on a donor's behalf?
Okay, so it depends on what it says in the actual enduring power of attorney. If you've written one where it starts kicking in immediately, then it can do so immediately. But if you've cancelled one of the clauses at the end of the document and you say that it's going to only start when you've lost capacity, then it will start when you lose capacity, and usually the person who's the attorney has to apply to the State Administrative Tribunal to declare that they've lost capacity before it can start.
Yep. And again, another linked question, which is if there is a disagreement between the enduring power of attorney and the donor, presumably when one has come into immediate effect, about how finances should be used, whose wishes should be followed?
The donor, of course. As long as they've got capacity, the donor's wishes should be followed. But if the donor is losing capacity or their actions are pretty dubious, then you can again go back to SET and ask them to declare that they've lost capacity, and then the donee, the enduring power of attorney, can then start making decisions. But as long as there's capacity, then the wishes of the donor should be paramount.
Excellent. And so my next question is for Etta, which is, can an enduring power of attorney agree for the donor to act as a guarantor?
It would often, almost always, not be in the best interests of the client. So I would say no. Unless someone wants to add anything to that.
Agreed, no.
No.
So that's a nice short answer.
And the reason for that is because there's a conflict of interest usually.
Yeah.
And when you're acting as an enduring power of attorney, you shouldn't put yourself in a situation where you're conflicted with the interest of the other person.
Yeah, and why would you put that person at risk on behalf of someone else, whether it's the attorney or somebody else? Makes no sense.
So I think we're going to ask this question to everybody, but I'm going to start with Etta, which is, can an enduring power of attorney directly benefit from agreements they are signing on behalf of the donor? For example, could the EPA approve the sale of the donor's home and then approve the use of the sale proceeds to fund the building of a granny flat on their property?
No. So the granny flat issue is an interesting one. So generally no. If they need to take responsibility for the consequences. Correct me if I'm wrong here, ladies. But if you're building it on a granny flat on another person's title, that might be okay if you put in the subsequent protections in place. So, for example, I'm investing a whole bunch of money in another person's property. Can I have my name put on that title? Should anything go wrong, I get my money back. So those protections for decisions like that, I think, need to be put in place. So if it were me personally, I wouldn't do it, because the granny flat situation is limited time. If it's a person with Alzheimer's, for example, there will be a point at which you can't lock them in the granny flat. So you need another plan for old age. So whilst you might be able to do it, it may not be necessarily in the long-term best interest of the client. So that's my view.
So I would say definitely not, only because I think, so the first part of it is, can they sign on behalf of the donor? I think the answer is yes, I think. Can an enduring power, can they directly benefit? No, because there will be a conflict of interest. And again, you need to get permission of, like, you might need to seek directions from SAT about whether, you should go ahead, whether it's within your authority. Now, in terms of the granny flat, if a person with capacity comes to us and asks, what do I do? We are not experts in this. Legal aid is not a property law expert. We are not funded to provide advice on that. We would usually tell them you need to seek legal advice, because there's so many repercussions when, the spouse, your child and the spouse split up, or, it's so, you can lose your entire life savings in this granny flat arrangement. So could the EPA approve the sale of the donor's home and then approve the use of the sale proceeds? They can technically do it, but should they? I would say no. Yeah.
Anything to add, Justine?
I think that's really important, is that they can technically do that. And so if you're setting up an enduring power of attorney, it's worth considering that they can technically do something like that. I think the rule of best interest, though, always comes into play, and it would be hard to demonstrate that that was in the best interest of the donor, even with the granny flat, because they're fraught with danger. It would be really hard to demonstrate that that was in the best interest of the donor and the conflict of interest. Yeah. But interesting to think that it could technically take place. And of course we know, because we've had cases exactly like this, that it does in fact take place. So it's another warning for people to be very careful.
And probably some good advice from financial counsellors is to encourage people not to rush into decisions, because it may be that the decision sounds good in theory, but in practice doesn't suit either or both parties. So if the decision is made for a person to go into residential care, there is allowance for respite. So use that to ensure that the person is comfortable with the decision to go into care as well as the care facility before you rush out and put the family home in the market. There is provision for that. And similarly, if you're going to be moving in with family, or it may be that you trial that situation before you rush and sell the family home, because you may not get on. Yeah. So what happens, you may have a quick pathway into aged care because you don't get on and you have to get out, but you can't go home.
Yeah. I guess it's that at that decision-making point. So, for example, financial counselling, the inaffordability of housing, we're seeing people, look at what their options are. So I think for our sector, be having that legal advice or saying to a client, really, you should consider seeing what these risks are.
So I'm going to ask Justine the next question, which is, what can I do if I'm concerned an enduring power of attorney is not acting in the best interests of the donor?
Okay, I think we have covered this during the session, but we'll go over it again because it's important to know that it's very easy to revoke an enduring power of attorney. It's as simple as you can tear it up, but we always recommend that people do a very simple letter. We've got a basic letter that we can provide, a form letter, where you state that you are revoking the EPA from a particular date. You need to make sure that obviously the person who was your EPA gets a copy and they're aware that their authority has been revoked. If you have lodged an EPA at any banks or financial institutions, you need to make sure they get a copy of the revocation letter. If you've lodged the enduring power of attorney at Landgate, again, you need to make sure that a copy of the revocation letter is lodged there. There will be a cost, and if you decide that you're going to have a new enduring power of attorney and you choose to lodge that at Landgate, there will be additional cost involved there. So you can revoke the EPA, but you need to make sure you follow the path. You contact all the places that had a copy of that document, and you make sure they get a copy of the new document. It's always good to follow up with a phone call or visit the bank and make sure they got the letter and they understand those changes have been made. You really want to make sure your bank accounts are secure. So all of these things, though, you can do if you have capacity.
Excellent.
And that's the key part. You need capacity to make an EPA, and you need capacity to revoke an EPA as well. If your capacity is in question, it will be very difficult for you to pursue revocation.
So this is our last question before we move to the questions from the floor, and I have a couple waiting for us. So, Vani, can enduring power of attorney or guardian make changes to the donor's will?
No, they cannot. That's because anything that uses the discretion of the person who's made the instrument, the donor, you can't do it. So you can't do wills, you can't vote for them, and there's a couple of other things you can't do. So again, if you're not clear, it's good to call an advisory body like the Office of the Public Advocate to see if you can do it. But definitely you can't do changes to the will, unless there's like an order of the Supreme Court, I believe, or something. Yeah.
Very seldom happens.
Yeah. Nice, simple no. That's good. So that concludes all of our, I suppose, frequently asked and common questions. So we're going to move on to the questions from the floor. If we are moving towards the end of the webinar, so any questions we don't get to, we will follow up with an email response to you. But I have two up here already. The first of which is, for a commercial EPA arrangement, is it with the agency or business of the EPA or the individual staff member within the organisation?
Well, certainly with the public trustee, it is the public trustee, which is a person who has an agency behind them. So it's the organisation. Because the staff member can change.
I don't know whether I'm potentially interpreting this question, but from a financial counselor's point of view, if they undertook the role of an EPA, is that the question, would be with their organisation or as an individual?
I personally don't know of any financial counsellor that, like in a professional situation during an EPA, it would probably be more for their own individual circumstance that they might. So I'm not sure, maybe that's...
I think if it wasn't like an accountancy firm, for instance, it would probably be the actual firm rather than the individual, because you need continuity if the person resigns or...
I think there's provision for both. So, for example, if you've got a trusted accountant, you would name that person because you trust that person. You don't trust their colleagues who you may not necessarily know. With a trustee company, it's obviously the organisation. So it will depend, and I guess it's at the discretion of, but the organisation may say that, we don't do that. So there may be some lawyers or accounting firms or other firms that don't.
It could be a reference back to the protocols where it's check your own organisation's policies and procedures as well. The next question I have is, and I think we'll probably move through everyone here, which is, do you have suggestions for how an EPA can protect themselves from accusations of misuse? So, for example, if the older person does want to fill up your car with petrol or pay for groceries. I'm going to look straight at you, Justine.
When you're an enduring power of attorney and the person has capacity, then you have to follow their instructions. So that's important. You also have to use good judgment, and you have to think about what is in the person's best interest. And you also need to be really honest and aware with yourself that when you are in that role, you have sway with that person. You can influence that person because you're probably spending quite a bit of time with them. You're their trusted person. They've set the enduring power of attorney up with you. So you need to be aware of that. And I would always suggest that people err on the side of caution. So if you think this could cause trouble, don't do it. If you think, your brothers and sisters are going to get upset if they find out, your mother is filling up your tank every time you take her shopping, or that she's paying for your shopping every time, then don't do it. And I would also add that because at Advocare we work with elder abuse cases, and we are aware that frequently financial elder abuse starts exactly that way, with somebody offering to pay for petrol. And after a while, it becomes an obligation. It becomes an expectation. It's the same with paying for the shopping, and then suddenly it's bill paying, and then it's paying off car payments, and then it's buying a car. This is how you can slip into financial elder abuse very easily. So I think as an enduring power of attorney, you should always err on the side of caution.
Do you have anything to add to that, Vani?
Yeah, you should definitely maintain 2 separate accounts. Don't intermingle your cards, for instance. Keep records, keep receipts. The more, I don't know if it's a good word, the more anal you are about record keeping, the more you'd be able to show your siblings or any other jealous parties that you've done the right thing. And again, I totally agree with whatever Justine has said, that, that I think you need to err on the side of caution. And if you feel uncomfortable taking it, I think it's best to terminate that relationship, particularly if you feel that it's going to be trouble for you. You can, again, while the person has capacity, while the person has capacity, you can say you want to get out of that arrangement, and you can stop being their, by agreement, you can stop being their power of attorney if the arrangement is getting uncomfortable. But if they've lost capacity, you can't just abandon the role. You need to apply to SAT, basically, to ensure there's a continuity of someone taking care of the person's finances.
I might just add also that, banks have got some really good products at the moment where you can set up bank accounts, and you've got electronic banking, which pretty much keeps a record of just about everything, including direct debits and so forth. So you've got that as a good way of keeping a record of the transactions, but then you also keep the receipts. It's important to remember at some point in time you might be asked for information around that person's income and assets, so it's important to have that information readily available. And maybe it's good practice to also produce the bank accounts or statements to siblings or other family members to say, look, this is the spending. If you've got any questions, I've got some of the accounts. And most people can very reasonably look through and think pharmaceutical products, reasonable amount of groceries, and that should alleviate a lot of people's concerns. So I think when people are open and honest and really transparent about what they're doing, it causes a lot less suspicion among family members. It's when people say you can't see it, you can't see anything, that families start to get a little bit concerned. And some of that is through loss of identity. But I'm an equal child. Why do you have all of the knowledge around our equal parents? So sometimes it's dealing with the emotional side of things as much as it is the financial.
I think what Vani said was spot on in regards to record keeping. So in the regional areas, especially with cards, like the old Australians, remember the old passbook accounts, and they'd like to go in and they'd see what was in their account. And now that we've gone pretty much cashless, the other person's got the card, they might not be getting the statement. They really have no idea what's going on in their account until it's too late. So I guess the person that may have the EPA, keep the receipts, have the statement, but also do a reconciliation and actually write on there, because sometimes the actual transaction would be very vague, or it might not actually state what it was for. So I think the record keeping to protect yourself as a person of trust is of high importance.
That's also a really good point of showing the person, regardless of whether they've got capacity or not, hey mum, hey dad, hey whoever, this is your bank account for this week, you've got this much money in the bank. So that just reassurance that you've got some control over your finances.
Excellent. That is our last question, but I was going to ask Leanne, as our financial counselling representative, is there anything else you think we haven't covered?
I would really like to understand more, as I said, about someone's wishes. So we know about wills and we know the general EPA form, but if someone's quite strong in what they want, what happens with that document that you could actually say, well, the person in trust has actually followed those other instructions in regards to their care or things like that? Where can they put that, or who could hold that so that...
So Palliative Care Australia is producing some very good advanced care plans, and I'm not sure about the estate planning side of things.
Do you mean like the Advanced Health Directive? Is that what you're talking about?
So, I'm not too sure it's the exact sample, but he said for a person to write down, like what they have their capacity, all their wishes, whatever that may be. So some would be, like your will is quite, straightforward. That person would have to follow that. But when it's generalist wishes,
Well, with the Advanced Health Directive, you should keep one with your doctor, your GP.
okay.
You can provide it to if you're going into hospital, you can give it to them. Generally, the recommendation is you give your GP and your other healthcare professionals. I think with the EPA, it's good to give a copy if you've done it to all the other non-EPA children, for instance, so that everyone's aware of what's happening. But that's...
It might be that you have a very broad income and assets statement, for example, on the financial side of things, and you say, I own a house, I own shares, I own this, but my shares are gifted in my will, so I don't want you to sell shares, or if you sell shares, they're the very last thing I want you to sell. Don't sell my home until you're absolutely certain that I'm going to be in a residential care facility, but I really want to be at home. I suggest people, if there's a possibility that they might be drawing near to needing either in-home care or residential care, visit some facilities and say, I want to go to this type of facility. I've heard this type of care, in-home carer is really good. The costs associated with that. I've looked at a suite as opposed to a room. I know that I can negotiate on the price of a suite. It might be $800,000, but I know I can get it for $500,000. So don't put me in a $500,000 room when you know you can get a cheaper room. So it's having some plans, doing planning. If you're planning a party or a holiday, you invest a lot of time and energy in that. So plan for your new home and think about how you're using your current assets to finance that, and tell people what the order of selling off assets, if you sell them at all. You might say, I've gifted the family home. There are a lot of situations, family home to finance the aged care, but they might say, well, look, I absolutely don't want you to do that unless it's the last resort. So you might then need to rent out the family home. What are the tax implications of that, etc. So,
and I guess that it's following those decisions and making sure that the EPA does that. It's like, well, what are those?
What I love here is we are right at the end of our allotted time, and I think what this demonstrates is that we could talk and talk and talk. If you do have questions that you would like answered, you can email advocacy@advocare.org.au, and one of our advocates will either answer your question or put you in touch with the right person. Thank you, Leanne and Etta and Vani and Justine, for spending time with us and contributing to this webinar. We are going to say goodbye